All right, let's get started. Welcome back, and man, interesting week for politics. I don't know if you've all been following, but there's been some hearing. I don't know anything about it. But we're going to talk about corporations in politics today, which is actually a much lighter subject, thankfully, than what's going on out there in the Supreme Court world today. I will only say one thing about these hearings, which is that a lot of students read judicial decisions and they think they must be right, that they think that this must be the law. We're going to learn today that the Supreme Court got a lot of things wrong in the past. I'm not even sure they got Citizens United right. And if the confirmation hearings, or the investigation of Kavanaugh has taught you anything, it should teach you once again that just because people are on the Supreme Court does not make them automatically right. And you are entitled to question. You are, in fact, expected to question. So we're going to talk about some cases today that have been questioned, have been overturned. Austin was overturned by Citizens United. Maybe Citizens United will be overturned next. The issue about corporations in politics is a decision made by 9 individuals. Those individuals, the makeup of that court changes over time, and accordingly, the role of corporations in politics changes over time. So I invite you in your writing and in your thinking and in your studies to be critical of these decisions. It's inherently, the Supreme Court is not supposed to make political decisions, but obviously they do. Decisions like Roe v. Wade are cut very sharply across partisan lines, and people are concerned about nominations for particularly those reasons. So corporations in politics tends to also fall sharply along those lines. And different justices coming from different parts of the political spectrum support or oppose money in politics. So I invite you to think about that as we talk through some of the material for today. The other caution, caveat, is that speaking of being critical, this is not my expertise. This is hardcore con law stuff. I have studied this for a few years. And I hope to guide you through it, help you through it, talk you through it. But I hope that those of you who are impassioned about this will, raise your hands and your voice and join in a discussion today to try to advance our understanding here as well. The Citizens United case and its law is one thing, but I think its progeny is interesting. So we're going to talk about a couple different concepts today. So what's the goal for today? Well, we're going to talk about some big stuff as we round out our conversation on corporations and society. We're going to talk about the conflict between money and power. We're going to talk about the need for free speech and the rights of citizens, whether that is effectuated or discouraged or drowned out by so-called moneyed interests, or whether that's really the most powerful vehicle we have for advancing the cause of free speech. We're going to talk about corporate personhood again, try to reevaluate what corporations are, whether they really should be understood as an aggregate of individuals, or a nexus of contracts, or a creature of the state, or a form of property, or a pure legal vehicle. So all these concepts we've been working on, we're going to come back to. We're going to talk about corporations as political actors, corporations that engage in lobbying, corporations that participate in elections. We're going to talk about political participation generally, and we're going to try to distinguish between participating in issues versus participating in campaigns. We're going to talk about direct expenditures and indirect expenditures. And, at the end of the day, I'll admit I don't understand all this fully. I don't think the Supreme Court understands it fully. I think there are issues in Citizens United they haven't thought through. I think this is one of the toughest areas of law today, the issue of corporations and the Constitution. So I'm not going to resolve these issues for you, and luckily you're not tested on them. So you don't have to get the answers right. I don't have the right answers. I hope to ask the right questions and help you think about this and help you think about writing your articles. So there are a couple things to set up, right? First off, are corporations people? Common thing people say. Corporations are people now because of Citizens United. Is that a fair characterization of Citizens United? Well, no. There are things that people can do that corporations can't. Is anyone here married to a corporation? Might be married to your job in sort of one sense, but you can't marry a corporation. Corporations can't marry. They can own property. They can't marry. They can't vote. They can influence elections, but corporations don't get to go to the polls. They don't get to cast a vote. So corporations are not people in the sense they can't vote. Corporations can't adopt children. People can adopt children. Corporations can't adopt a child. There are other things corporations can't do that people can do. But in some senses, corporations have legal personhood. Corporations can contract. Corporations can sue and be sued. Corporations can hold property, can hold intellectual property. And fundamentally here, they can aggregate huge amounts of wealth. And money is power, speech is power, so these issues get complicated. Corporations are political actors as well, but there are things people can do that corporations can't. Corporations cannot, at least not yet, hold office. And, as I mentioned at the beginning, corporations also can't direct corporations. Sort of an interesting quirk, actually. That last one, I think, is the one I can push on the most. I mean, why? I understand that corporations can't adopt children. I'm okay with that. I can understand that corporations can't vote. You could create them artificially. I can understand that corporations can't hold political office. But why can't corporations run other corporations? Why do we need humans to do it? Maybe something to think about. But there are certain powers corporations don't have that people do. So corporations are not people in all senses. That's a misstatement. But corporations have some features of legal personhood that become relevant. And maybe that's because corporations are collections of people and best understood that way. Or maybe we just don't really understand corporations very well at all. So let's talk about the world as it existed before Citizens United and try to set up what happened in this case. This was the biggest case in a while in corporate thinking, and it really mattered because it severely affected a lot of people. In the early United States, as you might recall from my first couple lectures, corporations required an act of Congress. You couldn't just file a document with the state of Delaware, the Secretary of State of the state of Delaware or California, who, by the way, anyone, fun fact, I think you know, so don't raise your hand. What is the new rule for California corporations? Anyone catch this news flash? Yes, Mary Beth.
You have to have women on the board.
Have to have women or a woman?
Well, it depends on the size. If it's 5 or less, they actually have to have 2 women. And if it's 6 or more on the board, they have to have 3 women.
So you have to have women on the board in California. So that's a really interesting development in corporate law. And for those of you, I hope that you've all started writing your papers. If you haven't, another hot topic for us to think about today. Right? And by the way, if you do think about that topic, I would ask you to think about a couple things. One, you could talk about the effect of diversity on boards. Right? And I think it has been shown, I think you can find empirical articles, that diversity on boards increases the breadth of thinking, improves the products of companies, especially as they focus on diverse markets, helps them avoid certain risks, that are becoming more prevalent today as the rights of women are being better understood and appreciated. At least I like to think they are, as you've seen some major CEOs' heads rolling. The board of Nike among them. You know, the board of Nike was sold for promoting a men's club or a boys' culture or a frat room culture or locker room culture, whatever you want to call it. So there's a lawsuit going on against Nike right now. So, you know, you might think of this as moving further in that direction against that sort of, you know, breaking up the men's club. On the other hand, there are always unintended consequences. So it's already difficult to be a corporation in California. Are companies going to reincorporate elsewhere to avoid this? Is there some unintended consequence to it beyond that? Is there some cost? So those are things to think about when you think about these issues. Try to always look at both sides. Anyway, corporations used to require effectively an act of Congress in order to be formed. And so as a result, there was a big concern that the way that you got a corporation was by carrying favor with your congresspeople. Right? I mean, that's not too uncommon. You basically have to lobby to get a corporation. And in the early United States, corporations were very different. There were very few businesses, at least by my research. From what I can tell, in 1791, there were 5 business corporations in America. 1791, I don't know if I misspoke. 1791, when our Constitution was signed by our 13th state, we had 5 business corporations. Most were colleges, municipalities, or some type of religious institution. In fact, as we go through here, some of you may belong to religious institutions. Those religious institutions are most likely a nonprofit corporation. And the rights of that religious institution to publish books, to support candidates, is directly impacted by the decisions we'll think about today. Some of you may be affiliated with non-religious organizations. Some of you may be affiliated with some of the major ones, the NRA, Greenpeace. These are corporations, and they speak, as you may have noticed. The NRA and Greenpeace have different messages, but both speak loudly. And so the concept of the corporation has changed over time, and so also kind of footnote to the conversation is Justice Thomas, in writing Citizens United, talked about the original meaning. I think it's interesting to talk about the original meaning of corporations. When the Constitution was formed, corporations didn't have the meaning they have today. So we did read a case a little while ago, Chapter 3. We read a case called Trustees of Dartmouth College versus Woodward. You may or may not remember this one. Justice Marshall, Chief Justice Marshall, wrote the opinion in that case. The case pertained to a corporation, and the state had attempted to change the terms of the corporation, the corporate bylaws, basically the contract. And in that case, Justice Marshall said that corporations were a creature of state law and a contract between a state and the company, and a contract that the state could not unilaterally breach. And then I think some of that aspect is still true, this idea of a creature of state law, but state statutes, Delaware Statute, Model Business Corporations Act, that has come out since that very old decision, 1831, I think, 1800s. These more recent modern statutes have said unequivocally that the state is allowed to change the terms of a corporate charter, of an ongoing corporation. So that concept of a unilateral, of a contract that can't be breached seems to have diminished. The other concept that existed and seems to have fallen by the wayside was that prior to the Civil War and prior to the 14th Amendment, you may or may not recall, the 14th Amendment came about after the Civil War. It's also known as the Equal Protection Clause. And before the Civil War, states would form a corporation. So if you formed a corporation in Pennsylvania, it didn't necessarily exist in New York. There was no need for New York to recognize that under the Constitution. There was a concept called comity, but there was no constitutional requirement. After the Civil War, however, and because of the Equal Protection Clause and because of the 14th Amendment, other states have to respect the existence of corporations in this state. It's also the same reason that Texas has to recognize gay marriage licenses issued by the state of Massachusetts. Similarly, Texas has to recognize Pennsylvania corporations under the Equal Protection Clause. Something interesting to think about, that 14th Amendment had such an impact. The 14th Amendment also has an impact because it incorporates something called the state action doctrine. And so when the state acts, it must act constitutionally. And when some private corporations act on behalf of the state, I think one of you is writing on prisons. Is that right? So who's writing on prisons? No? Prisons. Right? Yes, that was the topic? Yes. Sorry. 15 came at me today. But that's great. I'm glad you've all shared that with me. An issue about prisons is prisons used to be a state institution. Prisons have been privatized. But private prisons still operate under state auspices. There is at least a good argument that the 14th Amendment extends constitutional requirements to private prisons. Does that mean that a prison guard who is employed by a state penitentiary that is a private corporation, does he have the same obligations as an elected official? These are all unresolved questions, by the way, just to let you know. I'm not here to give you answers today. I'm here to hopefully in our apex of our conversation about corporations in sight, to leave you with questions that are worth being answered. So, all of this about corporations is all good and well. And one more point that I actually have on my notes here. I should have mentioned this earlier. The other feature about corporations that makes them different from people. Do corporations have Miranda rights? Does anyone know? No. Corporations don't have Miranda rights. What are Miranda rights?
They're the rights of criminals when they're being investigated. They have to disclose, or they don't have to. Self-incrimination. The whole.
It's the right against self-incrimination.
Yeah.
You have the right to remain silent.
That's
Anything you say can and will be used against you. We've heard that one before. Corporations don't have that right. They're different from people in that way. In fact, corporations can be compelled to speak. Corporate speech is really pretty fundamental. How are corporations compelled to speak? Well, corporations have to make disclosures. Those disclosure statements are compelling, and corporations are also not protected against unreasonable searches and seizures. So it's a long list of things that make corporations different from people. Is it enough to change their rights to make political speech? Yeah.
Well, I found that interesting. I was wondering, I didn't look too much into it, but Joel, that electronic cigarette company, just got ransacked the other day, and they took thousands of documents. So I'm wondering what kind of warrants or what they needed to be able to get in there. They just basically walked in and took all this stuff. They're investigating them for
It's like,
targeting minors in the cigarette.
if you throw that up on the blog, maybe some folks would add to that. I mean, this is a tough day for me to teach, right? Because we're talking about corporations, constitutional rights, criminal procedure, due process, the 14th Amendment. We're bringing a lot of law together today. And as you pointed out, right, Juul cigarettes, they bust down the door. They seize their hard drives. They seize their computers. There's no right against unreasonable search and seizure. Corporations aren't exactly people, but they are formed of people, and they do engage in politics. So let's talk now about corporations and their actions in politics. And I'll try to, as we go along, focus our conversation as we try to understand where Citizens United came from and what it means. Corporate political contributions and bribes were a huge issue in the era when you needed an act of legislation to create a corporation. Why should the legislature allow Mary Beth and not David to create a corporation? Well, one reason that seemed to work is because Mary Beth would either promise or did give political contributions. And so the use of money by corporations to gain favor in politics is quite old. The Tillman Act of 1907 was the first attempt to put an end to this. What did the Tillman Act do? Tillman Act of 1907. Samuel.
Prevented corporations from donating to political campaigns.
No campaign contributions, right? No campaign contributions, no independent expenditures. The Tillman Act prohibited corporate managers from using quote-unquote treasury funds, basically any money left in the treasury, any corporate profits that weren't distributed, to make campaign contributions. The idea being this wasn't a violation of people's rights because the shareholders could contribute themselves. And then we passed the Federal Election Campaign Act. What is the Federal Election Campaign Act? Sort of moved the pendulum the other way. We've got a lot of pendulum swinging here. What did FECA do? Federal Elections Campaign Act. Moving the pendulum the other way, yeah.
It permitted spending, but only through separate segregated funds.
Yeah, and those funds are going to be important. What were they called?
PACs.
A PAC. A Political Action Committee. Some of you may be involved with some of them. There was a famous been scandals involved with these. You know, Mary Beth, you probably know some of the scandals. You have a political action committee.
For office.
Okay. That I'd love to hear more. What was the name of your political action committee?
Friends of Mary Beth Cusick.
Yeah, and this advertisement paid for by the Friends of Mary Beth Cusick. That's a disclosure statement, by the way. We're going to come back to that disclosure statement. So why did you form a PAC?
Because if you, as a candidate, at least in Pennsylvania, you can collect money up to you, the candidates. So if you make a PAC, you
Mhm.
can, accept contributions easier, and, it's just, the reporting requirements can be parceled off to somebody else. David has one too, maybe
Oh.
you'd like to take over.
So we have two PACs.
Yeah, it's also
Friends of David Tamsey?
Yeah, actually.
Uh-huh.
It's also very burdensome and very hard to like keep up with the paperwork.
Yeah.
And counties have their own requirements as to what you need to file versus the state.
In addition to the state.
Yeah, so when you get a letter from the county saying you need to file, you might not have to file with the state. So there's this big chart that you have to follow each year.
And it changes each year.
Yeah, quarterly cycle.
And it costs some, and there's registration fees, it costs money.
Yeah, and
Right.
during election time, there could be 24-hour reporting on certain size amounts of contributions, so it gets very.
So you have disclosure requirements.
As a candidate, I mean,
Yeah.
as a candidate, you're out there supposed to be shaking hands and meeting voters, and if you had to do all this reporting on your own just as a candidate, it would be really burdensome.
So if you're rich, you just hire an accountant to do it all.
Yeah, they're probably your accountants that specialize in running these PACs.
Or you try to do it yourself.
So PACs then are political action committees, and they're formed by citizens. They can be formed by corporations. They can be formed by anyone. But what did your PAC do? Your PAC made advertisements, right? Your PAC made speech. Generally, PACs only do one thing. They make speech in favor of a particular candidate or cause. And so we'll see that that feels less problematic for some reasons. So if you give money to the Friends of Mary Beth Kuznick, you know that that money is going to go to advertisements supporting her and her causes. If you give your money to Friends of David Tamsey, you know that that money is going to support David and his causes. And that may be less problematic than if you give money to, for example, the Corporate Business Council, another nonprofit, which might have a lot of different intentions. So the purpose of establishing a PAC is so that people who are supporting a political cause have a repository for this money. In contrast, a shareholder who buys shares in a corporation, does a shareholder buy shares in a corporation usually because they want to pronounce a political message? Does anyone here have any shares in a company? Mary Beth, do you have any shares in a company as well as a PAC? So what do you have stock in?
Well, my aunt was a telephone operator, so she left me like 20 shares of what ended up now being Verizon.
Oh.
It was Bell Telephone.
Say, I don't know, 20 shares is probably split a couple times, so.
Yeah.
So that's done well. So you're a shareholder in Bell Telephone, right? And Verizon now. And I suppose you hold those shares. You hold those shares because you are trying to influence politics?
Not really.
What's the purpose of having shares in Verizon?
Well, in my case, I just think it's in memory of my aunt, and I just sort of keep them and see if they grow.
See if they grow financially.
Yeah.
I mean, most shareholders are purchasing shares not to make political statements, but to increase their financial capacity. So a shareholder who buys shares in a corporation usually does so for reasons completely unrelated to politics. I mean, you may choose not to buy shares in a company you really dislike, but sometimes people will buy shares in a company because they like its politics. I mean, it seems like with Dick's Sporting Goods, we've brought that example up. The BlackRock Fund doubled down on Dick's after they stopped selling guns. And the BlackRock Fund essentially said, we're doing this because we like their politics. But that's sort of the exception, not the rule. And with a money management fund like that, we really always have to ask, is that really right? Or is that simply a technique for BlackRock to try to get more investment from people that are into this? So when we're thinking about PACs, we have to understand that they are created for a very specific reason, and that narrow reason of supporting politics. And in general, I'd say 99% of the time, people do not invest in corporations for that reason. So then comes Bellotti, one of our first pre-Citizens United cases. And in this case, what was the law at issue here? It happened to do with Massachusetts. Anyone remember? What was the law? It was actually a criminal law on the books in Massachusetts that became the subject of the litigation known as Bellotti. Anyone? Yes.
It prevented corporations from placing political ads for or against pending referendum.
Yeah, and it didn't just prevent it. It had a criminal sanction that forbid corporations from engaging And not just in placing ads. I think the language was broader. I think the language was broader still. It said, from engaging in any efforts to influence public opinion on any matter submitted to the voters, unless that matter was directly affecting the business or the property of the corporation. Corporations should not speak, it said. Corporations should not speak in politics. It had this narrow exception for if they had an interest, but it said corporations should not speak, could not influence, not with their money, not with their actions. So several banks were upset about this. They were upset because there was a tax law up for referendum. A referendum is when the citizens can actually vote to change the law. Usually, our government works the same way corporations do, that we elect representatives, the representatives make laws. That's the usual process in most states and certainly at the federal level. I actually don't know. Have there been any federal referendum? I don't know. Anyway, I believe all of federal law, but I'm not sure, and much of state law is done by proxy, right? Through appointed representatives. That's Republican democracy. And that's how corporations work also. We appoint directors, and the directors make policy. But voters in states have powers that shareholders don't have. They can actually put law into place through a referendum. And California does this a lot. Apparently Massachusetts did this. And so here we have an opportunity to really influence policy by talking directly to people. And the banks, I don't know which side of it they are on for the facts of the case, but the banks wanted to influence this income tax rule. They wanted to either say, yes, we should have more income tax, or no, we shouldn't have this graduated income tax. But the law expressly forbade banks, under criminal penalty, from speaking about this because it was not considered to be directly related to their business. The question in Bilotti was whether the Massachusetts law, this law that prohibited any corporation from engaging in any efforts to influence public opinion on any matter submitted to the voters that did not directly pertain to business, whether this Massachusetts law was an unconstitutional infringement on First Amendment rights for free speech. What was the holding? Was this an infringement of the First Amendment?
Yes.
Yes, it was. This was an infringement of the rights of free speech. And Justice Powell wrote the opinion for the court. He found that, well, this is the case that says we focus on the speech and not the speaker. The real message I take from Bilotti is that the First Amendment is not really designed to protect speaking. It's designed to protect speech. What is the difference between speaking and speech? Speech pertains to the listener as well as to the speaker. Many people will say, you have the right to speak. But maybe Bilotti is suggesting that it's more than just speaking in a vacuum. Others have the right to hear. I mean, if you speak, and if you're allowed to write whatever you want, but the government takes it all down off of your blog and no one ever gets to read it, you've spoken, but you haven't reached anyone. Has anyone here seen the new version? I mean, the old version had a little bit of this concept, but the new version of Fahrenheit 451. Anyone seen it? The new one? Yeah. So what happens in Fahrenheit 451? What's the state of affairs?
Well, it's all about like book burning and censorship, and it's the government is burning all books and basically censoring everything that is being put out for the public to read and talk about.
So they burned all books, but books have been burned, books have been banned throughout history. Oscar Wilde's Portrait of the Artist as a Young Man. It portrayed homosexuality. And that book has been on the ban list at many schools. I'm sure it still is at certain schools for its portrayal of homosexuality.
I think this week is Banned Books Week, by the way.
Oh,
It was either
yeah.
this week, last
But we have an
week.
English teacher in the room, so,
Yeah.
you know, we can more on this here. So Oscar Wilde is dead. Who cares about his rights to speech? By banning Portrait of an Artist as a Young Man, are we infringing on a dead person's rights? Does a dead person have right to speech? So is speech really about the speaker? Oscar Wilde spoke by writing this book. He's dead. Let's burn it. What's the problem with that? The problem is that it's not the speaker. It's the speech that we're preserving. Why? Because reading that book, adds to the intellectual community, adds to the dialogue, adds to thinking. Now, maybe, I don't know, I actually have never heard a compelling argument for banning books, but if anyone wants to present it, you're welcome to. But I think the argument is, I guess, protecting people from dangerous ideas. But as we'll see throughout this discussion, someone then has to arbitrate what is a dangerous idea, what is a safe idea. So Bellotti, I think, stood for this principle, and I think it becomes more intuitive when you think of Oscar Wilde. He doesn't care one way or the other whether or not you read Portrait of an Artist, because he's dead, and dead people don't care about anything, at least not from my understanding of how things work. But you might care. You might care because that's an important book. It talked about a lot of important issues of the time. It gives us a mirror, into a different time and a different perspective. So Justice Powell, writing on the nature of the speech, found that the Massachusetts violated the amendment. And the court, and he wrote as follows: the court below framed the principal question in this case as to whether and to what extent corporations have First Amendment rights. We believe the court posed the wrong question. This is not about the rights of corporations. This is about the speech. The Constitution often protects interests broader than those of a party seeking vindication. The First Amendment in particular serves significant social interests. The proper question, therefore, is not whether corporations have First Amendment rights, and if so, whether they are coextensive with natural persons. Instead, the question must be whether Section 8 abridges that First Amendment, whether the Massachusetts law abridges that which the First Amendment was meant to protect. We hold that it does. Bellotti stands for the notion that the First Amendment does not protect the speaker, it protects the speech. And Massachusetts argued against this, saying that the law protected individual opinions. How would it protect individual opinions? How could a law banning corporations, banks from being involved in the political system protect individuals? What was their argument? Yes,
Your
Dave.
speech won't be drowned out by the larger corporation and larger voice.
The drowned out theory, right? Also known as the anti-distortion argument. That corporations speak with a megaphone, and we all can only speak with our voices. Corporations speak with immense power. And so individuals will be drowned out by the greater volume of corporate communication. Corporations can drown out speech. I think as the internet has proliferated, we found that not to be true. I've seen companies get taken down by a tweet. But this is pre-Twitter. What is this, 1978? 1978. But the argument Massachusetts raised was this anti-distortion argument. That comes up again in Citizens United. It keeps coming up. The idea that money and power wielded by corporations will preclude others from participating in the process. It's an important dimension, but in this case, that was not found to be the case. Justice Powell dismissed the arguments, and he found that people can decide for themselves whom to listen to. You don't always listen to the loudest person, unless that person's me. That's only because I'm standing up here. Decisions are for the people. The people should have the words, and they can decide which ones to believe and which ones not to believe. And so this law precluded people from having the option to learn for themselves. I see this as the marketplace of ideas. And I think here Powell made a powerful statement saying that ideas are valuable, and we should promote a marketplace of these ideas. Now, we will see in constitutional law there is, of course, doctrine against this. Hate speech, for example. Preclusions against hate speech. You can't scream fire in a crowded theater. There are things you can't say, but we meet these with strict scrutiny. Justice Berger concurred. He discussed the difficulties of distinguishing banks from media corporations. What's the difference? Why would this, what about Fox News? Are they allowed to speak? Does anyone here think Fox News makes political speech? Anyone here think CNN makes political speech? MSNBC? Comedy Central? I mean, if any of you saw Saturday Night Live, was that on ABC? Looked like political speech to me. Media companies make political speech. How do we distinguish between media companies and banks? What if a bank also owned a media company? Where do we draw the line? That was the concurrence from Justice Berger. An issue that remains to this day, an issue that remains through to Citizens United. Limiting the abilities of corporations to engage in political discourse curtail the freedom of the press, unless there is an exclusion. We'll see that legislatures try to get around this by then saying, except for media companies. See how that played out. There was a dissent, of course. These tend to be very political issues, whether corporations can engage in politics. Justice White, Brennan, and Marshall dissented, and they said, quote, oh, by the way, what they're going to say is the anti-distortion argument, which has not gone away, which is persistent. And that goes as follows. Hence, as the case comes to us, the issue is whether a state may prevent corporate management from using the corporate treasury to propagate views having no connection with the corporate business. Justice White argued the First Amendment concern for robust political discourse was at the root of this issue, and that Massachusetts was facilitating robust discourse. Facilitating robust discourse by restricting the use of political speech in the corporate speech and corporate assets in the political arena. Corporate speech, they argued, these three justices, could drown out the speech of individuals. Whether that balance is correctly drawn is a matter, these judges thought, for the legislature. They had the ability to decide that. The legislature was the place to decide whether corporations would drown out public speech. The other justices, the majority opinion, found that no, the legislature would violate the Constitution in doing so. So just on the topic of Bilotti, this topic of the anti-distortion rationale, I'd like to get thoughts on this. Who here thinks that the majority was right? Would like to explain why corporate speech, why the speech is valuable. Does anyone agree with that? Well, then take the other position. Then, if none of you raise your hands for that one, why would corporations drown out people, John?
I'll answer the first one. I think if you're going to put responsibility on corporations for a lot of tax base, for example, right, then they should be able to have a voice in how that is going to be arranged. Because otherwise, the issue could negatively impact their business, drive revenue down, and that would erode the tax base anyway.
Yeah, so I think here John's point is that, in fact, how do we know that a political decision won't impact the business? I mean, first off, it seems to me, I tend to agree with this notion. Why would the bank care about the law unless it did affect their business? Massachusetts here is deciding whether or not this tax law affects banks. Why should the Massachusetts criminal justice system decide whether a tax law impacts bank revenue? But what about this other argument? This anti-distortion rationale has been very pervasive. 3 justices dissented. Does anyone feel that their voice is not heard when there's someone louder in the room? Yeah.
Yeah, I think that's the true thing. Like what I say, no one really cares. Our column, like Duquesne said. But if like Amazon comes out and supports someone, then anyone that's like, oh, Amazon's great. I use their service all the time. I guess I'll get on board too. Like people that are uninformed can just see like a tweet, a blurb, this, that, about this company that they enjoy saying something, and they're like, without forming an idea for themselves, like, oh, they support it, I'll do it too. But I don't have that power.
Sam.
But a regular old rich person has a bigger voice than you, can buy a bigger marathon than you can. Should they not be able, should we be sort of curtailing the rights of people with more money so that everybody has sort of equal volume?
Would you like to respond?
Jeez, we worked together summer. This is all summer. I did that flashback. That's just how it works. I mean, there's nothing really that we can do except try to level the playing field, so to speak. Like, I always thought when I was growing up, like, how do people call like a press conference? I never understood it. Can I just be like, hey, press conference, show up? Like,
You can, but they may not show up.
Wait, what?
You can call a press conference. You just maybe no one will show up.
So, I don't have an avenue really to get my voice out there, and like other people have these resources to be able to do that. So trying to speak for the common man would have, say, a little bit of a step up, I think that's helpful.
A quick reply, if you have one.
I would say that one of my initial point stands that a regular old rich person can call a press conference of people simply because he has money and some clout through that money will come and potentially, get that conference. The other thing I would say is that, to me, and this is sort of jumping off what John said, I do think that the speech at issue rather than the speaker is what the First Amendment focuses on, and that any restriction of that has to meet strict scrutiny.
I saw Joe's hand next, and then Maria.
I
You're
just
still.
think is it fair to punish someone because they're rich, because they worked hard, because they have more than other people have, and tell them that you have to restrict their voice because they work for the position that they're in?
Well, I mean, I think in the case here, what if a person earned money so they could speak? I mean, is that permissible? Maria, thoughts?
Yeah, I was just gonna sort of back up and say, I don't think it really should focus on the corporation, but rather like the brand in terms of like, whether Amazon says something or Kanye West says something, Kanye West has his own brand, he's not a corporation himself. And so people are gonna say, oh, Kanye West wears a Make America Great Again hat, so I like Kanye West because I like Donald Trump. And so it sort of is a web.
Or maybe more like I like Donald Trump because I like Kanye West. I think that's the political side.
Well,
Yeah.
It depends, I think, on the lens through which you're seeing it. But that's beside the point, I'm just saying that I'm going.
Kanye West is wealthier than my corporate. I have a corporation, and I promise you, Kanye West has way more money. So can you explain to me why my corporation, which has $6,000, should not be allowed to speak, and Kanye West, who has $20 million, can? What's the distinction?
I
Yeah.
was going to say that actually it's a bit of a double standard because the Supreme Court has upheld the individual contribution campaign limits for rich people, but haven't for corporations. So a rich person could just simply make a corporation, put their money into it, and then spend it individually as they please.
Mary Beth.
There's another issue, maybe this is more appropriate with Citizens United, but when you donate to a PAC or to a candidate as an individual, above, what is it, $50 or something like that? Above a certain amount, you have to give your name, you have to give where you live, you have to give your occupation, you have to give all this information, and that's so that in general, we can search and see who's donating to what politicians and how influence is. A corporation has two domiciles. They're domiciled in their state of incorporation and then where their principal place of business is. So at some point, it gets kind of unwieldy if corporations are allowed to donate to candidates or PACs, speech notwithstanding. It's just
Well, that's
part
where
of the
super
law.
PACs come in at.
Please.
Well, I think if we think about what we were talking about last week with corporate social responsibility, we expect these companies to go out and, they may not actually be doing it, giving, clean water to poor countries or cleaning up the environment. But if we're expecting that level of social responsibility from these corporations, I think at a certain extent, those corporations should also have a voice in the politics that affect their ability to do so.
Mm-hmm. If we're give and take, right? And I think this also comes back to the notion that if corporations, and this was, I think, Rehnquist's dissent, really, I think, also elevated that point. He argued that corporations were chartered by the state, sort of took the opposite approach, but he argued that since corporations were chartered by the state and they existed only by the privilege of the state, then the state could limit them in any way they wanted. But if the state is compelling them to act for the benefit of society the way the state feels, shouldn't they have a right to express what societal benefit means? So let's talk about our next case then, Federal Elections Commission versus Massachusetts Citizens for Life. And by the way, in case you can't tell, Massachusetts Citizens for Life had a political agenda. Right? What do you think Massachusetts Citizens for Life was formed to do? It wasn't formed to make money. It's a political corporation. Sam.
Speak out against
Speak out against abortion.
abortion.
Speak out against abortion in the post-Roe v. Wade era. This is a case in 1986. And there is a law, the Federal Election Campaign Act, Section 316. Now, 2 U.S.C. Section 441B, also known just, affectionately as 441B. And that prohibits corporations, similar to the Massachusetts rule, prohibits corporations from using Treasury funds to make an expenditure in connection with a federal election, although they can through a PAC. And so Massachusetts Citizens for Life, by the way, again, this corporation was formed for the sole purpose of speaking out against abortion, right? Saying Citizens for Life. You didn't buy a share of Massachusetts Citizens for Life because you wanted to make money. You bought a share of this because you wanted, in fact, it was a nonprofit, non-stock corporation, so you couldn't get a share of stock in this company anyway. It was established to foster respect for human life, including the unborn, through educational and political activities. Now that's political speech, and that's an important perspective, right? We have a major debate going on. We have a huge debate in American society about this at the time. And so in 1978, Massachusetts Citizens for Life distributed a newsletter, a special edition. Basically, and the NRA does this, by the way. The NRA will give you a scorecard called the NRA scorecard. It will tell you who to vote for. If you want the NRA's agenda to be promulgated, the NRA will tell you who to vote for to effectuate that. And Massachusetts Citizens for Life did something very similar. They essentially promoted a scorecard and said, vote for candidate A because they're pro-life, and vote against candidate B because they're pro-choice. So this corporation did not do it through a PAC for the reasons that Mary Beth and David explained. A PAC is cumbersome, burdensome, and difficult. And moreover, this was the only reason this corporation, this nonprofit, non-stock corporation existed. And they challenged 441B, which, like Massachusetts, although not criminal, 441B said that corporations could not contribute to federal elections, could not make an expenditure in connections with a federal election. So what was the result here? Was 441B upheld or struck down? It was struck down. This was an unconstitutional law. There is no more 441B. There's just 441A and C, I guess. So what was the reasoning here? Why was it unconstitutional to prohibit Massachusetts Citizens for Life? We have established they could have done this through a PAC. They didn't do it through a PAC. Why didn't they just form a PAC? They said it was burdensome. Is it okay to burden corporations with this requirement to have a PAC? The answer is no. Why is that unconstitutional? The justices here, Brennan, Marshall, Powell, and Scalia. Probably familiar with those names. You know that they stand generally on a side of the aisle. Delivered the opinion of the court, although I think actually that's a little bit mixed. By the way, if you ever go to SCOTUS blog, it actually will show you the judges on a political spectrum and affiliate them with the particulars. It's very, very interesting to see how often the Supreme Court lines up on partisan lines or not. Interesting as we're going through a process right now. If anyone's wondering why the Republicans didn't agree to have a vote already, or pushed for a vote already and didn't just wait for an investigation, because maybe the appointee might be someone who will further their political agenda, right? The justices have some connection to politics on both sides. And so these justices, Brennan, Marshall, Powell, and Scalia, delivered the opinion of the court, and they said that this was unconstitutional. As applied to the special edition, the newsletter clearly involved Treasury funds, so the law applied, but it violated their restrictions. The question was not whether or not this law applied, but whether the Congress had a compelling state interest. Because Congress can limit speech where there's a compelling state interest. They can prevent you from screaming fire in a crowded theater. They can prevent you from saying, let's murder all the Jews. There are things you can't say. I mean, I just said it, but I didn't mean it, okay? Just to be clear. I don't mean that. I'm being didactic here. Maybe a little inflammatory. But there are reasons that we have a reason we don't permit that type of speech. And in fact, that type of speech is permitted in certain cases. But the Constitution does allow a balancing test when there is a compelling state interest. Why was that not met here? Justice Brennan conceded that direct corporate spending raises the prospect that resources in the economic marketplace may provide an unfair advantage, that people could be drowned out, this drowned out concept. But that concern was not presented by this institution. Why? Because this institution was created only to make this message. Massachusetts Citizens for Life is not Target stores. Target stores exist to make money. Target stores might speak, but that's not their purpose. If you're a shareholder in Target, it's because you're hoping the stock price goes up because they stop violating data security laws and stop having credit cards get stolen. I hope so too. The funds are here, and effectively MCFL is a PAC. And so basically what MCFL stands for is that corporations, nonprofit, non-stock corporations organized solely for a political purpose are treated like a PAC under this law. Rehnquist, White, Blackmun, and Stevens concurred in part, dissented in part, and argued that Congress, again, has the authority to draw these lines. Congress gets to make these decisions, not the court. Effectively saying this is a political decision, but also supporting the decision. And that brings us to Austin. Austin, by the way, is overruled. Austin is no longer good law. That's unequivocal. Citizens decided if it did one thing, it overruled Austin. So what was Austin? Austin was the pendulum going back the other way. What did Austin have to say? Under Michigan's Campaign Finance Act, Section 54(1), corporations are not permitted to make independent expenditures in elections using Treasury funds. Now, media corporations were excluded, so it doesn't have the Bilotti concern, right? And that wasn't every justice's concern, but under this Michigan law, media corporations were excluded. So Fox News can speak, but Bank of Michigan cannot. Then we have this organization, which is kind of like Massachusetts Citizens for Life, but slightly different. What was the name of the organization at issue here? What was the organization that was trying to speak? Michigan Chamber for Commerce. Has anyone had any dealings with a local Chamber of Commerce? Maybe John, have you ever dealt with the Chamber of Commerce? Does anyone know what the Chamber of Commerce does? They support the interests of local business in general. It's a kind of a general ambit, right? It's much more general than promoting pro-life messaging, right? And advertising a pro-life candidate scorecard. Promoting business agendas is much broader. I mean, there's small businesses, there's large businesses, there's private businesses, there's public businesses, there's nonprofits, there's limited liability companies, there's sole practitioners, there's partnerships. And they're all funneled through this Chamber of Commerce, which then acts as a sort of general body to advance the interests of business and commerce in that state. So it is a nonprofit, but it has multiple purposes. It has political purposes and non-political purposes. Let's reduce the corporate taxes. That's political. It has non-political purposes, like let's get all the CEOs together and have them talk about best practices. It's not particularly political. And it was supported how? By dues. Dues from members, this is important, 3/4 of whom were for-profit companies. So effectively, we have a broad type of organization that fulfills a number of purposes, both political and non-political, doesn't have a very discrete agenda, and it is funded by for-profit businesses. And they sought to place an advertisement in a newspaper supporting a candidate. Not any different from what Massachusetts Citizens for Life did, right? Citizens for Life, the NRA scorecard. Vote for candidate A, vote no for candidate B. Same story here. But the difference here, the distinction, the twist, is that this was a multi-purpose organization and it was funded by for-profit businesses. Now the question is this law permissible by a compelling state interest? Is there a compelling state interest, or is the interest in free speech higher? And here we get the different result. Here the pendulum has swung the other way, and the justices who I just mentioned, who dissented, they now have the opinion. They now have the majority. And I don't know if anyone's keeping track here. I think the difference here was Rehnquist. Is that right? Let me just go back to my notes here. That was the swing vote. Yes, Rehnquist. Rehnquist is now in the court. Now we're in the Rehnquist era. And it was Justice Marshall, Chief Justice Rehnquist, Brennan, White, Blackmun, and Stevens delivering the opinion of the court. And they said that independent campaign expenditures were at the core of political speech. This is political speech. And the fact it's a corporation doesn't remove First Amendment protection, but we have a compelling interest in the other way. For one thing, the act, they thought, merely burdened the state. Merely burdened the corporation. The corporation was not prohibited from speaking, just burdened. They were burdened because they had to operate through a PAC, through a segregated fund. And as we've heard from our friends of, that it's burdensome. It burdened political speech. It still permitted it, but it burdened it. It required it to flow through a PAC, but that was permissible because there was a compelling state interest. Michigan contended, and the court agreed, that the advantages of a corporation, the ability to do business collectively, the fact that corporations could aggregate wealth, these mitigated some of the reasons that we have free speech, right? That people would be drowned out. This concept was brought forth again. And instead of supporting what the public needed, it supported economically motivated decisions of investors and consumers. The availability of these resources make a corporation a formidable political presence, even though the powers of the corporation may be no reflection of the power of its ideas. The court also considered whether the act was narrowly tailored, and because it had what Bellotti did not have. What did Bellotti not have? An exemption for media corporations. And here the court says the exemption for media corporations means this rule is narrowly tailored. That's an important distinction, but we'll find that Citizens United wasn't so sure. The chamber argued that the fact it was a not-for-profit should bring it under MCFL. But here, no, that's not the outcome. Not all nonprofits are treated equally. It matters, one, are they formed for a purely political purpose? And two, it seems it matters if they are getting funds from for-profit companies. That seems to be what distinguishes Bellotti from Austin. Scalia, of course, dissents. He was on the majority the last time. He called the whole thing Orwellian, speaking of banned books. And Kennedy, O'Connor, and Scalia, who joined this dissent, also dissented. They argued that this court was validating censorship. The law was validating censorship, and the court's effort to distinguish between political speech by business organizations and political speech by political organizations meant the court was picking and choosing. Why is the court in a position to determine that Massachusetts Citizens for Life is political and the Chamber of Commerce is not political? Who is making that decision? And who is to say what a political message is? I mean, how do we determine what messages are political and what are not? Now, Austin, not worth dwelling on because it's been overturned, but it's important to note that it was distinguishable from Bellotti because that corporation had funding from for-profits and was formed for a general purpose. The court seemed to find that that was enough strength, and maybe it was just a difference in the composition of the court. This is why the composition of the court matters. Maybe it was Rehnquist that tipped the scales. I don't know. I wasn't there. But Citizens United overruled it in 2010. Really seminal decision. So what was Citizens United? What was that corporation? What does Citizens United do? Citizens United attempted to speak. What did Citizens United say? Yes, Megan.
They had a video about Hillary Clinton.
Yeah, a video about Hillary Clinton's a nice way to put it. They had a movie, they called it Hillary, the movie, and it wasn't very flattering. In fact, it was pretty clearly a statement against Hillary Clinton. I don't think anyone's disputing that Hillary the movie was not favorable to Hillary Clinton, and so this corporation put out this movie. Now, the issue is not that they produced a movie, by the way. What was the issue? The issue is not they made a movie and made it available. I mean, if that were true, there are a lot of movies that wouldn't exist. And by the way, we're going back to the banned books here. Yes, Alexander.
It had to do with like a time limit between an election.
That is fundamentally important. I'm going to talk about electioneering next. So there was a concept called electioneering, which is when you're near an election cycle. But what I want to get at, it wasn't just that they produced a film and you could buy a ticket and see it in theaters. You can go see films in theaters, right? I forget the name of it, Farmed or something. There's a whole expose movie about how factory farms are horrible for animal rights. That's a clearly political movie, right? And it's available in theaters. You can go and buy a ticket. You can see it, right? That isn't the issue here, right? You know, and if it were, why is that a problem? Yeah, Maria, your statement. Yeah.
The original question is about express advocacy under 441B, I think.
Yes. What did they do? What were they doing with this movie? they were giving it away for free. They were using Treasury funds to make the movie available for free, on demand. This is pre-Netflix, or barely Netflix. This is like in the early Netflix era. I don't know exactly how Netflix picks and chooses their movies. I watch a ton of nature documentaries. And by the way, I highly recommend this new one. It's really awesome. It's called Animals with Cameras. And it's a series by PBS where they have made cameras, and then they have scientists who attach them to animals. And there's this really cool one where they have chimps, and they give the chimps the cameras, and they willingly put these cameras on and run around the forest. And it's awesome. It really gives you a really cool perspective.
The chimps willingly put on a camera?
Yeah, they hand it to them, and they're so excited about it. At least that's how it's portrayed. But, you know, it's a political show, really. It's anti-chimp rights. It's pro-chimp. It's anti-chimp. So you can have these productions, but you know it's available for free on Netflix, or Netflix is a paid service. But you know, in this case, I guess it was on back when there was the on-demand button on your DirecTV or what have you, and you could get that show for free if you still have that. So they made this available for free. They were using their campaigns to do this, and they were doing it during a period of time that was defined as electioneering. The Bipartisan Campaign Reform Act of 2002, the BCRA, prohibited electioneering, as defined as corporations that broadcast using cable or satellite, pre-internet, by the way. I don't know. I don't actually. That's an open question. I just realized I don't know if the BCRA pertains to streaming on the internet. Anyway, prohibited corporations from broadcasting film that clearly referred to a candidate for federal office within 30 days of a primary or 60 days of a general election. That's electioneering, trying to essentially change people's minds. And that's what this video was meant to do. There was really no question about it. Hillary the movie was really bad for Hillary. It really made her look bad, said a lot of bad things about her. And it came out in that period. So it was electioneering. The 441B applied. The 441B that was upheld. Yes?
For corporations, I don't get why they're motivated to use the general treasury fund. Is it just because it's easier to access, because they can take more of it than they would through a PAC? Like, why do they want to use these?
Mostly because it's easier than a PAC. And having a PAC requires time, additional money, disclosures, filings. I mean, if you do it through a general treasury, you don't have the same requirements about reporting who your contributors are. I think a big part of it is that. And that comes up in this decision. I am speculating a little here, but my understanding of it is that when you donate to a PAC, the PACs report major donors. That becomes public. And that might, as Thomas, I think it was Thomas, who had the opinion that sort of disclosure would chill speech. I mean, if everybody knew, now everything's on the internet forever, right? So if you gave $100 to Citizens United and it was a PAC, now for the rest of history, everybody knows that you helped support a movie opposing Hillary. Might that discourage you from doing it? Maybe. Sure. That might chill speech, versus if you could do that anonymously. So I think that was one issue. There was also the administrative burden, the expense. So there are good reasons why a company would prefer to use their general treasury funds and not form a PAC. So it clearly has the effect of chilling speech to some extent. The question is whether the state has a compelling state interest such that they are permitted to chill that speech to that extent. Is it reasonably related? That sort of test. So we have 4 issues in this case, and really only one of them is important for our purposes. One is that the case had procedural issues, and for those of you who love constitutional procedure, there was one of the major stare decisis cases. There's an entire concurrence basically just around the concept of stare decisis. Stare decisis is a very important concept in American law. I don't mean to dismiss it. I just really know nothing about it. So, fine. So I'll move on. Although I won't quite move on. The issue here was that a lot of decisions after Austin have cited it. And so if a case essentially is cited a lot, it sort of becomes ensconced in the law. And the principle of stare decisis, or let what's decided stand, is the idea that we should not change the rule lightly, the rule of law lightly. And the way that I think it was Roberts who wrote that concurrence got around that issue was he said that none of those decisions which cited Austin were expressly asked to overrule it. And so none of them sustained it. So Austin was actually never sustained by the Supreme Court. It was made once. It was made on faulty, flimsy grounds, and therefore stare decisis did not prevent the court from deciding the case very broadly. And by the way, actually, Citizens United just wanted to get their message out. They didn't actually need to overrule Austin. I think it was mostly, what's it called when other people, friends of the court, the Latin for friends of the court, amicus. It was mostly the amici, who persuaded the court to overrule Austin. So that was number one, the stare decisis issue, yay, constitutional procedure. Number two, was Section 441B constitutional, right? In burdening political speech, was 441 constitutional? And that's the key issue. That was the second issue in the case, and the answer is no. 441B is struck down, and Austin is overruled. Bye-bye, Austin. The third issue, which was not in your text, related to whether or not BCRA's prohibitions on electioneering media before an election violates the First Amendment, and yes, it did. This concept of electioneering. Why prohibit speech right before an election? That's when it's most important. That was also struck down, although that's more broad. It doesn't pertain directly to corporations, but for those of you who are interested in free speech, you can look at the Citizens United case for its non-corporate aspects about this electioneering concept. I think John brought it. And finally, did the BCRA's requirements for disclosure and disclaimer violate the First Amendment? And that's also relevant. The answer, as you can tell, is no. Because every political ad you'll see in this cycle has that disclaimer and that disclosure, paid by the friends of Mary Beth Kuznick. Justice Kennedy delivered the opinion of the court. And he said that in prohibiting business corporations from using Treasury funds, Section 441B is an outright ban on core political speech. It is unconstitutional. What about the PAC? The fact a corporation could use a PAC is irrelevant. Corporations generally do not because it's a hassle, as we have heard from our colleagues who have tried to deal with it. And moreover, a PAC is a different institution. Mary Beth is not a PAC. She is a human being in this classroom. The PAC is a separate entity. It is not her and she is not it. So her rights should not be abrogated simply because she could speak through another vehicle. If Mary Beth has First Amendment rights, and she does, I think I can say that pretty definitively, not a constitutional scholar, pretty sure Mary Beth has First Amendment rights. She has rights of free speech, right, within the balancing test bounds. The fact she can form a PAC and speak through it does not abrogate her rights, according to the majority. It also went on and said the government cannot rely on the anti-distortion argument as a justification. The government cannot rely on the anti-corruption, made an anti-corruption argument. What's the corruption argument? The corruption argument is essentially saying that if corporations can make this speech and can give this kind of financing, if corporations can, if Citizens United, let's say it was not a nonprofit, but let's say it was Target, and Target makes Hillary the movie free, or a penny, subsidizes DVDs of Hillary the movie, there's a chance that Donald Trump is going to love Target and is going to do them favors. Does it look bad for Target? Yeah. You could see how you might make the argument that if Target is making Hillary the movie free and putting it in the front of the store, Donald Trump's really happy that Hillary is being, demoted in this way. Can you see an argument? But the court here said that that's not enough, that this might have this appearance of corruption, but this is not donating to Trump's campaign. That would be a problem, right? Target giving money to Donald Trump, you expect that's money for money. This is a little different. This is speech. It might be speech he likes, but that's not enough. And besides, if it's just speech and it's not direct, let's make a more general speech. Dix spoke by not selling weapons. That's political speech. That's speech that we should have rules, laws, stricter laws about sales of guns. They spoke when they did that. But there's no one particular person that was being supported by that. It's a little more diffuse, so it's hard to see how Dix would curry favor with a particular senator or congressman or representative by doing so. And the third argument, that this was bad for shareholders, that shareholders' rights would be abrogated. Are we going to protect shareholders in this way? Very fundamental for this class. And again, the court said no. Shareholder democracy works. If you don't like that the directors are making movies called Hillary the Movie, you'll vote them out of office. I think that's the one we can actually push back the most on in this class. I'm not so sure that the shareholder democracy works that well. But We'll come back to that point. So, on the disclosure and disclaimer, per Justice Kennedy, the requirements for disclosure are permissible. Those are a reasonable restriction on speech. They do chill speech. If a message says, paid for by the Friends of Mary Beth Kuznick, and if the Friends of Mary Beth Kuznick are listed on a website, yes, there is some chance that if people don't like Mary Beth's message, they will follow the trail and not like those people in accord. And that may mean some people don't give that money. That does chill speech a little bit. But that would seem to be a reasonable restriction on speech. So the disclosure and disclaimer requirement stands. On the other hand, we have a concurrent, not really on the other hand, but sort of in the middle, the concurrence. Chief Justice Roberts made the point that if Austin were upheld, how would we distinguish media corporations again? This media corporations issue keeps coming up. Media corporations clearly need to be able to make political speech. Otherwise, no one would watch the news, right? It'd be totally boring. If Fox News and CNN and MSNBC truly were absolutely nonpartisan, they would not have the viewership they do. We watch them because they raise political issues and they highlight political speech, right? Joe.
Isn't that how the news started, though? It really was people just, here's the news to inform you of what's going on without a political tone on it, and then it started to get more ratings as they gave that.
Well, I'd have to defer to people in the room who have been watching the news for longer than I have. But I would suggest that no news that reports can ever truly and entirely unbiased. I think that is the journalistic ethos. You were a journalist. Yeah. Yes. Please speak. Please speak to the issue.
Since I have been watching news longer, at one time there was the doctrine of fairness. So they put on, let's say, Kennedy for 5 minutes, then they had to put on Nixon for 5 minutes. And
Yeah.
they were very careful about this, and they tried to make things be balanced. And there were only 3 networks. There wasn't MSNBC and Fox and all these other little, it was ABC, CBS, and NBC.
Mm-hmm.
And that was your choice, and they all pretty much tried to make the news be balanced.
I think there was another fundamental difference in that era when you had broadcast as opposed to cable news, in the sense that in order to broadcast, you have to get spectrum from the government. And I don't know this as a matter of doctrinal law, but I think there was some issues about, it wasn't quite state action, but you needed essentially, you can't just broadcast on the airwaves, on a UHF or a VHF, if anybody remembers what those are. But if you go to your grandparents' houses, those dials that go up to 13, that was UHF, and then like the next to like 37 or VHF. I still remember those.
I was under the understanding that when the news started becoming a thing, it was because the government carved out 1 hour a day, here's the news, and it was a government kind of thing where we're allowing you this 1 hour to provide the news, and then it expanded into companies that said, we'll get advertisers to help pay for our company, and those advertisers would subsequently influence the agenda of what they reported.
Yeah, I don't know the history of the news. I do know that spectrum is granted by the government, whereas cable is not. And so I think there's a fundamental difference there. But
I think that doctrine of the fairness thing was because of the spectrum. I think
Yeah.
They had, in order to keep their license to broadcast, they had to provide equal time, they always call it.
yeah,
Equal time.
and I think that has to do with it being effectively government. The airwaves are government property. Right? The government owns our airwaves, and so I think that is part of it. But again, an interesting topic, well beyond the ambit of my knowledge.
If you're really interested in it, the TV show The Newsroom,
That is my favorite show.
oh, it's so good. But it provides an
That's
interesting
exactly why I brought it up.
So let's go to the dissent. We have a new justice. Sotomayor is now on the court. So we have that new voice on here. She joins with Stevens, Ginsburg, and Breyer. They concur in part and dissent in part. And Justice Stevens, who wrote the opinion, writes that the question is not whether some corporate speech is banned. The question is how its distribution is paid for. The question is about paying for this distribution. Claiming that the corporation is the speaker, writes the dissent, is misguided. The corporation is not the speaker here. and using this case, which concerns a not-for-profit, to rewrite the rules of how business corporations and unions and for-profit organizations participate is even more misguided. By overruling Austin, this opened the door to for-profit corporations making political speech, and Stevens thought that this was going too far. He made the argument that the framers didn't like corporations. By the way, Scalia said they did, and so they didn't. They thought about that. Okay, I'm not actually sure how relevant that is because I never knew of Stevens as an originalist anyway, and I'm not sure that that Scalia was right in this originalism. So, but Scalia's originalism, not to speak ill of the dead, but it was a little shaky sometimes, and I actually don't think in this case that the founders understood corporations the way that they are today. I mean, as I mentioned, in 1791, when the framers had signed the Constitution, there were only 5 corporations chartered in America, and the charter of a corporation required action by a state Congress. And the majority of corporations that existed, either by legacy or from England, were nonprofits, churches, universities. So I actually take issue with Scalia's taking issue with Stevens about the original meaning of corporations, but I think that's just not central. Okay. I actually tend to like Scalia's opinions. I think he sometimes when he makes originalist arguments that are wrong and are not based in originalism, I think it just raises a couple interesting questions about that. Okay, so I'll get down with my soapbox again. So why isn't the PAC good enough? Why not have a political action committee? Why is a PAC not sufficient? Justice Stevens says that it is. That allows the money to be channeled in its proper place, and if you're going to make a speech, make it through an organization designed to make that speech. Make a PAC called Enemies of Hillary, right? And it can put out Hillary the movie. No one says it can't. Everyone agrees that Enemies of Hillary, the PAC, can produce Hillary the movie, give it out for free, make a deal with Target so that Target, pay Target to put it in the front of their stores, not a problem. Why is that too burdensome? It wasn't too burdensome in Austin. The majority, again, the dissent's arguing, the majority paid no attention to the idea that corporate participation is likely to be what's called rent-seeking. So this is a quick economic concept. The idea here is that rent-seeking is spending money to get legislation that benefits you, confers an advantage, and essentially disrupts a competitive marketplace. We can talk more about rent-seeking in another class, but it's one type of economic failure. There are several types of economic failures, and if corporations are spending their money to get a personal benefit, they're not spending that money for a societal benefit. It's sort of wasted money, and so that's considered rent-seeking. Justice Thomas concurred in part and dissented in part, and Thomas actually would have gone further and would have gotten rid of the requirement for disclosures. And I hope we can see that at least. I mean, if your name was forever on the internet attached to a political cause, to some extent that may inhibit you from doing it. Now that's not necessarily a bad thing, but it does chill, and if I give money to Friends of Mary Beth Kuznick and she goes on a rampage and says some outrageous things, my name is going to be attached to that. That might chill my, or maybe 20 years ago, someone donated to Judge Kavanaugh's campaign when he was in politics. And that's on the record somewhere. And now that's an affiliation that is going to be persistent. That could chill speech. You don't necessarily want to have that affiliation. Question?
So if you donated to my PAC, you were donating to my
Yeah.
campaign, so I could run for state legislature. So by doing that as an individual, if you gave more than $50, I had to take your name and take your occupation, and that's all. Anybody can go and search. I ran in 2012. Go look it up. You can see all the people that donated to me, which,
Yeah.
it's not too many, but whatever. But so that's the way it is for individuals donating to candidates or PAC supporting candidates.
Sure.
It's just
Sure.
different, and it's-
I'm only suggesting that chills donation in general, right? I think we can agree that it. Well, I don't know if we can agree. I'll point it to you. I'm not saying corporations should, people should, can't, whatever. If your name is attached to a cause for the rest of history, are you going to be more hesitant before giving money to that cause, as opposed to if you could give anonymously? I personally would. I would be more hesitant to give to a person. A person can change too, I mean, maybe 20 years ago, nobody knew what was going to happen at the hearing this week. And Judge then, Prosecutor Kavanaugh was running for office, and he had a PAC, and you contributed, and now your name is affiliated with that. You didn't know, so that, to me, that can discourage, because you don't necessarily know how a person will act in the future, any person. And your opinions might change. Maybe you like to, there are people who were for the NRA and don't support the NRA anymore. And maybe there are some people that are running for office and that's on their record, or a variety of other reasons. Yeah.
To put on an extreme example of what happened in the McCarthy era. People were blacklisted
Yeah.
because they might have believed in 20, 30 years ago. Your name's on a roster list
Yeah.
for something you did in college, and now you've lost your career.
Yeah, I mean, how many of us have, believed in college in something they don't believe in now? I mean, I did. I mean, my views have changed since college. I actually think that's a good thing, that, as we grow and as we learn, our views change. But if, I wasn't a communist, but as someone who was and isn't now could be blacklisted for all of time. And that would chill your political speech in that area. Yeah.
Am I misunderstanding that it's individuals that get disclosed, but corporations don't get disclosed?
Corporations get disclosed. I think the threshold's higher. If corporations give more than $1,000 are disclosed. I think it's yes. My understanding, campaign. Now we're getting into campaign finance disclosure law, but yeah, my understanding is that corporations that donate to a PAC are disclosed, but the threshold for disclosure is higher. I think it's 50 for an individual and 1,000 for a corporation. Those numbers keep changing over time, but yes, corporations who give to PACs are disclosed.
But it's anonymous because it's under the corporation's name, not an individual. Is that the benefit?
Well, with Massachusetts Citizens for Life, if you gave money to Massachusetts Citizens for Life, that's not a PAC, and it doesn't have a disclosure requirement. So you might be and maybe some of you have. I wouldn't know. Someone in this room might be pro-life and gave money to Massachusetts Citizens for Life, and we can't find that out, even though Massachusetts Citizens for Life could have formed a PAC, could have made an advertisement. But if you donated $55 to Mary Beth, everyone can find that out for all of history. Does that make sense? Yeah.
Is it a dual disclosure that you have to disclose to the people, the stakeholders, and then the government?
I'll actually turn it back to our friends here. I believe that the people who administer the PAC are required to collect the names, and then they provide those lists to the government through a filing, the state, through the reporting system at the state, and then the state maintains that record, makes it publicly available. Is that accurate?
And you can do it, for a state office in Pennsylvania, you can research it through the Department of State website.
It's not really
But
good.
if they're using general treasury funds,
No, that's not correct. Then there would not be that individual reporting. I mean, if I gave money to a corporation, and that corporation uses general treasury funds, those reporting requirements are not there. I mean, you don't know what stock I own, right? So a corporation can raise money by issuing stock. I could buy stock in Hobby Lobby. I could buy stock in Dick's, right? Two corporations. They both, and I might choose to buy that stock because Hobby Lobby has a message, no contraception. Dick's has a message, no guns, different messages, different sizes. I could buy those. I could buy shares in that stock. I could sell those shares. And that's not public. That never gets reported. And Dick's can use that money to continue advancing that message. Buy stock in Papa John's, and you're basically supporting opposition to the whatever. You can buy stock in Nike. You can buy stock in these companies. Nike has ads that say basically Colin Kaepernick is a great guy, right? And he has a message. So Nike is making a political speech. You can buy stock in Nike, and no one is going to know that. It doesn't go on some kind of federal register. But you give $55 to Mary Beth or David, and that gets recorded. So if you give money to a corporation that donates to a PAC, also no. It's sort of, the corporation is a shield. It's going to shield liability, and it's going to shield disclosure of you. But the corporation itself would disclose, right? If the corporation would say this message is paid for by the Massachusetts Company for Life. This message is paid for, but it doesn't necessarily go back to you as an individual. Yeah. That's my, yeah, David.
Just gonna make a quick argument that it actually helps not show, actually helps law. Because when you, so for example, with Senator Franken, when he had his, I guess it was a scandal, those who donated to him have a record that they gave to him, so then they could say, I actually want my money that I gave to you not back, but given to a charity and for like victims fund or something like that. So I actually have a record, maybe I didn't keep my checkbook from 20 years ago, but I can go and pull up that I gave to you and on such and such a date. So now I want you to donate to a certain charity.
Well, I think David's right that it does provide accountability. But I don't know. I mean, I think on balance, we could ask a reasonable question as to whether it chills or thaws more. In part because you don't know that Al Franken is going to have a scandal and that you're going to be able to use the system to demand that he contribute to a charity. Whereas if you did give money to a cause and you didn't have to disclose it, you know, I mean, you could keep that record and you could choose to keep that record, but you don't have to. You don't have to have, and it's also, the idea of having everything I've done and every contribution I made politically available forever, certainly, you know, disincentivizes me to make some of those contributions. Right? There's some things you know. Well, I'm not sure if I support that enough. There's some things I'm glad this literally happened to me, guys. I got a letter from an agency saying, "Would you please support Kavanaugh?" Before this whole thing blew up, I declined for other reasons. Right? I didn't like him for his judicial record. This is before he turned out to be whatever. So, but you know, I mean, similarly, like if you're in the world and you're, you know, a law professor, you get invited to join these sort of things, and it matters. That stickiness is important. I looked at the candidate. I said, I don't really like his judicial record. I don't want to write a letter in support of him. Glad I did. Even more so. Yeah. There was something about his. Yeah. Really crazy week. Okay, but I think that overall the court did find that this disclosure chilled speech, and that was a finding of fact that was held. Maybe you can sympathize with that. Maybe, as David pointed out, there are some counter arguments, but that is where the court found. However, it found that the disclosure requirement was not so chilling as to not be reasonably related to this purpose. And Justice Thomas disagreed with that. Thomas had the position that actually this was unreasonable, and he would have gone further and said corporations can donate to politics, and they don't have to do it through a PAC, and they don't even have to say who the message was by, even a corporation. And the other 8 said, not so much. But at the end of the day, Citizens United is on the books, and corporations can speak in politics, and they do. And they do, and otherwise a lot of things that happen today would be challenged, right? I mean, I think that it's my opinion. I invite you to share yours, but Nike supporting Colin Kaepernick is speech. Dick's not selling guns is speech. And this is fully permissible. And, you know, whether or not you like that or not, you really need to look at Citizens United. You really need to look at whether or not this case was right or wrongly decided. Nike can speak much more loudly than I can. That maybe, you know, it's kind of Nike versus Papa John's, right? I mean, if you look at it a different way, now it's Nike speaking in one way, Papa John's speaking in another. So, I mean, I'm actually kind of sympathetic to the drowned out argument. I mean, it kind of reminds me of, have you guys seen Lord of the Rings, the old one? And they're climbing up the mountain, and there's this storm. And it turns out that it's 2 giants hurling rocks at each other. And that's sometimes what politics feels like today. I mean, Nike and Papa John's having an argument feels like 2 giants hurling rocks. A thunderous storm with fire and smoke and lightning, of which the most I can do is to not get crushed. So, actually, I think after Citizens United, we have some real questions about this drowned out argument that have resurfaced. And do we now have to aggregate all of our speech through the corporate forum? And that may not be bad. We may decide that's not bad, but we at least should think about those consequences. All right, so we have a couple questions here. The court left standing the FICA's direct contribution prohibition. So even after this, Nike can run an advertisement supporting Colin Kaepernick. Nike cannot give money to Donald Trump. Why? What's the difference? In fact, what's the difference between making a movie called Hillary the Movie and giving money to Donald Trump? Is there any difference between making Hillary the Movie and handing Donald Trump $1 million check? John?
The candidate could be beholden then to the corporation that directly gave the money.
That's at least the perception, right? I mean, if you saw that Nike cut $1 billion check, $1 million check, whatever, to a candidate, would you feel concerned that that candidate is beholden to that corporation? There's at least an appearance of impropriety, an appearance of corruption. This idea, and this is the term, a quid pro quo, this for that, tit for tat, this for that, something in return. The candidate might be expected to give something in return. The appearance of political corruption arises. And so it did not go so far as to permit a direct transfer, but it did permit speech. And independent expenditure is not a transfer, it's expression. So there's a difference between expressing through speech and expressing through money. They say that money talks, and that is true, but it is different when you use your money to make artwork. You can call a film artwork or not, or even a book, or even a polemic, or even an article. And even an article saying Donald Trump is the worst president in the history of the universe, that's fundamentally different than giving money to Bernie Sanders. It's just different. There's just a fundamental difference. And even writing an article or an article in favor. I mean, if you write an article saying Donald Trump's a great guy, is he now beholden to you? Well, maybe. I mean, maybe, but there's less of this appearance of impropriety, and we're more willing to permit speech than these direct kind of donations. So at the end of the day, do we know what corporations are, these things that are allowed to speak? What kind of person is this? Is there an answer? I think Citizens United leaves us even more lost than before. Is a corporation aggregate of the people? Is it speaking for its individuals? And, I won't say that Citizens United got it right, but I will say there's at least one aspect in which Citizens United, I think, got it wrong, which is the part of the decision that said that the corporation was speaking on behalf of its shareholders because shareholder democracy works. Right, the fourth holding in the case, right? The fourth holding in the case regarded, sorry, not the fourth holding, the, where's the source of that? I lost my thought on the matter. The rationale, it wasn't one of the holdings. It was part of the reasoning, and I think it was the reasoning of the majority effectively said that corporations were speaking on behalf of their shareholders, and that this was not a violation of shareholder rights because shareholders could vote their directors out of office. How many of you have voted for a corporation's shareholders? I haven't, and I get involved in this stuff, right? I mean, it's just not worth my time. It's a feature called rational apathy. It's really not worth my time. The vote doesn't matter. It won't count. I'm not going to get anything done with it. And there's so many other aspects too. I mean, can I really control a corporation through my shareholder vote? So this aspect, I don't know if the corporation is understood properly in Citizens United. This may be the way that Citizens United gets defeated, actually, if we can advance corporate theory and understand corporate law better. Yeah.
Like, if it's a non-stock corporation, they're not for, like, in the advocacy.
Doesn't even have shareholders.
There's
no shareholders.
All you do is just don't join it anymore.
Right. You can just stop paying. Yeah. So certainly with non-stock corporations, there's clearly no voting aspect. Yeah, John.
Did the court try to expand the decision to someplace it didn't need to be? Because Citizens United is a nonprofit.
Right.
So it almost seems
One of the biggest criticisms of the case is that they expanded it beyond what Citizens United asked for. It seemed almost activist. It seemed like they were actually going out of their way to have an expansive repeal of Austin.
it was like they had 3 cases before. They needed to change something.
Yeah.
They wanted to make it more common.
The claim in the case, and there's a good law review article, basically saying that, what's the name of the article? I was reading it earlier today. The article was, any minute now, Citizens United and the illusion of coherence. The goal of the court, the stated goal of the court in having this broad sweeping case was we're going to decide corporate campaign finance once and for all. And we're going to finally have a coherent law of campaign finance. This article was by Richard Hazen from Loyola Law School. It's in the Michigan Law Review. Recent article. Volume 109, for what that's worth. 109, Michigan Law Review, 581. Good article, although a little dense, at least for someone who's not a constitutional law scholar. And Citizens United and the Illusion of Coherence by Richard L. Hazen, Hasen. The citation is 109, Michigan Law Review, 581. Take a look at it. Exactly the point. What was the court trying to do? They're trying to solve this problem once and for all. And a huge criticism is they not only went too far, beyond what they were asked, beyond what the parties asked, but they didn't actually solve it. That there are still holes. Check out the article. It's interesting. But I agree. They didn't have to go this far. Shareholders, do they really have a voice? I don't think so. That's my view. I don't think shareholders really have a voice. I don't feel that I have a voice as a shareholder. And even institutions, there's so many competing interests. And would you really get rid of a director because they, for over $1 million political contribution, if the corporation was going well? I mean, waging a proxy battle against a corporation whose stock price is going up and whose sales are doing well is a sure way to decrease your stock value. Would you do that over $1 million contribution? I mean, you'd have to be very principled as an investor. And the investors, these aren't humans. These are also firms. They have fiduciary duties to their constituents, who are also firms themselves. I mean, we're so far away from human beings at this point. I have some real doubts about the court having understood corporations right. And I think that if Citizens United does get overturned, it'll be based on a new theory of corporations or a better understanding of large private corporations and how they act. So to summarize, I see we're out of time. Congress and the courts have really struggled to define how corporations should or should not be allowed to speak. There's a balance between money and politics. Money corrupts, but it also gets a message out. And I think if we look at what are some of these messages, I mean, should a corporation be allowed to write and publish books? Look at some of the materials that were produced here. So in a way, I think we can be sympathetic that without corporations, without the corporate forum, if it were just individuals that could speak, some of the most important, polemics would not be widely available. And there is certainly a value to speech. I mean, the fact that there are books in the library that are affordable, that you can access, that are online, that are free, movies. You can watch these movies, you can watch these shows, you can read these words, you can decide for yourself. On the other hand, my analogy of sort of the battle of titans between, for example, Nike and Papa John's, if you can even see it that way, or this is a battle that's raging on where we might be able to hear, but we can't speak, or at least Tyler can't. No one's going to listen. Well, we'll listen to you, Tyler. So corporations have struggled, Congress has struggled with this balance. And business corporations, they do have a constitutionally protected right. No one disputes they have a right to speech. The question is whether that right is can be restricted by a compelling state interest. So that's the balance. And Citizens United said that no, there is not a sufficiently compelling state interest to restrict corporate political speech. As a result, we have widespread lobbying. We have contributions by business corporations to lobbying. These are regulated by the law. And we now have corporate speech. And I think that the jury's out, kind of literally, on how this is going to turn. This was supposed to be the last decision. This was supposed to be the coherent theory. It's supposed to be the end of the debate. But you can read the article, you can, which has much more to do. You can listen to John's point, they went too far, or sort of my point that I don't think this is how corporations work, really, in terms of shareholder discipline. And there are some concerns I think we should all be left with. I don't know if the case was right or wrongly decided, but it's what we are living with right now. So I hope that gives you some things to think about, decide for yourself. Just a reminder, your papers are due next week, and so hopefully you're working on those. We're going to shift gears after this, and I'm going to become a lot more boring. for better or for worse, as we focus now on the nuts and bolts of entrepreneurship in the law. So I hope you enjoyed this Corporations in the Law module and got you kind of engaged with some of the ideas, and you sort of saw how important corporations are, and now you get to experience sort of the nuts and bolts, right? As we call it at the firm, the blocking and tackling. When we get back, we're going to talk about how to choose an organization. We're going to do some workshopping, and we're going to work through some problems that kind of small entrepreneurs face. And just as a reminder, all the material so far is not going to be tested, with the exception of maybe an extra credit question on the exam that could count for 5% of that or something. But fundamentally, your way of being assessed on this is your response paper, and I'm looking for your independent thought. In part, that's because there's so many different ways to view this, and I'm not here to tell you how to think. I'm just trying to encourage you to think. So, write your papers. You're not here to please me. I have a lot of different views on a lot of these topics. Next semester, next week, it's going to be much more clear-cut. So, have fun with the paper, and see you in a week.